This presentation is for you who is not aware of the fines and penalties for non-compliance with dangerous goods regulations. I'll talk about the US penalties, some examples of dangerous goods accidents, how to transport dangerous goods safely, and how to keep compliant. There are some published penalty amounts by the Federal Aviation Administration for hazardous materials. FAA, for those who don't know, is the equivalent of Civil Aviation Authority and is the largest transportation agency of the US government and regulates all aspects of civil aviation. The published Hazmat civil penalty amounts were effective 1st January 2023. Before we proceed, we need to understand the two terms used interchangeably. These are dangerous goods and hazardous substances. The US Department of Transportation term for dangerous goods is hazardous substance. Oftentimes, practitioners use the two terms interchangeably. At times, they refer to dangerous goods, articles, and substances as dangerous goods, and sometimes they prefer calling them hazardous substances. We are going to go through the penalties and also get to know the classification of the violations as given to us by the FAA. Violation of hazardous materials transportation law attracts $96,624. Violation of hazardous materials transportation law resulting in death, serious illness, severe injury, or substantial property destruction attracts $225,455. Violation of hazmat transportation law relating to training attracts between $582 and $96,624. A moment of silence. Is the amount cheaper than proper training or procuring packagings from competent manufacturers or suppliers? The answer is no. If you said no, kindly don't compromise safety for low budgets. When it comes to procuring dangerous goods training, packagings, cushioning materials, absorbent materials, and everything needed in the process of preparing dangerous goods shipments. The next question could be, well, those are US penalty amounts. I mean, how do they relate to me, a person coming from Australia? Yeah, I'm here to remind you that responsibilities are well stipulated in the regulations, and the shipper and operator are the key players in transporting dangerous goods. Therefore, they must be aware of their responsibilities. The shipper must comply fully with the IATA dangerous goods regulations when offering a consignment of dangerous goods to IATA member and associate member airlines and to the airlines participating in IATA interline agreements for cargo. In addition, shippers must comply with any applicable regulations set forth by the states of origin, transit, and destination. A reminder, the IATA Dangerous Goods Regulations Manual is the global reference for shipping dangerous goods by air and the only standard recognized by airlines, and it is a legally binding standard. Should also be reminded that the national legislation, for example, 49 CFR and the Global Field Manual, which is the IATA DGR, are fully compliant with the ICAO technical instructions. ICAO in full is the International Civil Aviation Organization, and it regulates operating practices and procedures covering the technical field of aviation. Besides the national legislation, we also have some state variations on file with IATA, and I gladly remind you that we have 18 state variations on file with IATA for United States of America. If you're planning to ship dangerous goods to, through, or from the United States of America, you're supposed to comply with the state variations, which are applicable to your shipment. So this is how state variations work. They apply to the transport of dangerous goods by air from the United States of America, in this case, through the United States of America and to the United States of America. You need to always check if the countries involved in your shipment routing have filed variations with IATA. If they have, then you're supposed to know and meet all the state variations requirements which are applicable to your shipment. Remember, sometimes a country could probably have filed variations which don't relate to your type of dangerous goods shipment. In that case, you just ignore. But in the case whereby the variation relates to your type of dangerous goods shipment, then you have to fully comply. Let's look at one accident for air transport. So I guess some of you were like, or the $200,000 plus is quite a big or large amount of money. But again, I would like to remind you that we have other costs which cannot be measured. For example, when people lose their lives. Let's look at this ValuJet flight 592, which crashed in May 1996. There was fire in cargo hold originating from chemical oxygen generators. All the passengers died and the crew. In total, the world lost 110 very important people. The investigation report indicated that the cause of the accident was due to incorrectly packed and handled dangerous goods shipment due to lack of training and failure to follow essential procedures. The second accident was that of the Pakistanis explosion in 2017, and this was road transport. A tank truck carrying 50,000 liters of fuel overturned. It's alleged the driver was sleeping. 219 people died and 34 others were injured. Earlier report suggested the explosion was caused by someone lighting a cigarette. Now, someone could ask, where did all the 219 plus 34 people come from? Yeah, it so happened that hundreds of residents rushed to the scene, and in the process, the tank exploded, and that's how they ended up dying. The last accident was that of the fire which broke out aboard MV Zim Kingston in the year 2021. It's alleged that the source of fire were the two containers carrying a chemical. The ship caught fire after more than 100 containers went overboard. Of course, sometimes, especially with the sea transport, we have long-term effects. And in this case, there were chemical burning to the fish. Dangerous goods can be transported safely by all modes of transportation, provided certain principles are strictly followed. The first one is training. Ensure that your employees are trained. Packaging, choose the right packagings. They should be of good quality, and also they should be allowed by the packing instruction. You have to go to the packing instruction and see which of the options given to you is suitable for your shipment. Proper declaration of dangerous goods has to be done. Accidents and incidents have to be reported. And finally, national legislation has to be followed. Let us look at the dangerous goods regulations, just a reminder to see which regulations apply to which mode of transportation. For air transport, we have the IATA dangerous goods regulations. For road transport, we have the ADR. It comes in 2 volumes, volume 1 and volume 2. For sea transport, we have the IMDG Code, which is published in 2 volumes, volume 1 and volume 2, plus the code supplement. The 49 CFR is representing the national legislation, and in this case, it is for United States. We also have the ADN, which is the regulations for transporting dangerous goods by rail. And now, this is a statement that I grew up hearing. Ignorance of the law and regulations is not defense. When it comes to dangerous goods transportation, there's no excuse. You have to follow the regulations. So I'm going to give you a few tips, what I feel you should include on your list for compliance. You must follow the latest regulations. Now, all the regulations that I've mentioned in the previous slide expire. The IMDG code is updated every 2 years. The ICAO technical instructions is updated every 2 years. The ADR is updated every 2 years. The IATA dangerous goods regulations is updated every year. The 49 Code of Federal Regulations is updated every year. So it's important that you refer to the current regulations. 2, check for updates on the regulators' websites. All those regulations that I've mentioned have supplementary information, which is usually published after the manuals have been published and distributed. For the ICAO technical instruction and the IATA dangerous goods regulations, we have what is called the addendum. And for the IMDG code and ADR, we have what is called the corrigendum. So always look them up so that you keep updated. 3, build rapport with institutions that have direct communication with the regulators. For example, when ICAO has an updates to communicate, they'll definitely reach out to IATA, and then IATA will reach out to its stakeholders, such as the airlines and the training providers who are accredited by IATA. And then ICAO will also communicate the same updates to all civil aviation authorities in their respective countries. So that's how information moves. Now, for you who is not in direct contact with any of the key stakeholders who are given the updates as they come in, you're supposed to keep in touch with the training providers or your civil aviation authority, so that as they receive these updates, they pass them over to you. Remember, ignorance of the law and regulations is no defense. When they train you, they always tell you that we have addenda or corrigendum, which could be published after the manual has been published. And they are legally binding standards. That means that if you don't refer to them in the process of preparing dangerous goods, and then you happen to violate certain standards, you could be fined or penalized. This is where the statement that ignorance of the law is no defense comes in. You have to ensure that you're updated. It's not anyone's responsibility to update you, but find a way of updating yourself. We have, I guess now you know the regulators. For the dangerous goods regulations, always check the IATA website. For the IMDG code, check the IMO website. For the ADR, check the UNECE website. And then for 49 CFR, check the FAA website. All right, and then number 4, acquire proper training. I have a few things to mention when it comes to training. Involve a dangerous goods expert when drafting both the statement of requirements and the technical evaluation criteria to attract and select a competitive training provider. Also check that the selected instructor is knowledgeable and skilled. Outsource and schedule training based on the employee function. Some employees require basic level of proficiency, whereas others require intermediate. So you need to know what level of proficiency you're giving to the employees. Do not organize for a basic course for a team which require intermediate level of proficiency. Remember that training content is going to differ. Also, create internal control for errors and omissions. For shippers, this can be done by carrying out pre-checks. Make sure that among your standard operating procedures, you have one where employees cannot give out dangerous goods shipments unless a colleague has subjected them to a pre-check. You don't need to draft these checklists. Just go to your dangerous goods regulations under index. It's one of the last pages. And there you're going to find the checklist for non-radioactive shipments, one for radioactive shipments, and one for carbon dioxide solid, dry ice. They are exactly the same checklists used by the operators when they are accepting dangerous goods. So in this time, or in this case, you're going to subject your shipment to a pre-check before errors and omissions are passed on. You're going to decrease the number of rejections. You're also going to increase your level of compliance. And lastly, consult experts when uncertain. For the CEO listening to me or any other decision maker, you can sign up an independent consultant or company from whom your employees will seek guidance in uncommon situations. Until today, I'm still learning how to ship dangerous goods. If this is my status, when I have worked with these regulations for more than 15 years, how about someone who has acquired training and their experience is of 1 year? They still need someone to guide them until they attain that level of confidence. Thank you so much for listening to me. In my next videos, I'm going to do my level best to break down the 2023 IATA lithium battery shipping guidelines. See you then.